Hello everyone, I'm Jayshree Raveendran here. I take immense pleasure in welcoming our guest for today, Dr. Amita Dhanda, who is Professor of Law and Head of the Center for Disability Studies at NALSAR, Hyderabad. She was closely associated with the drafting of the United Nations Convention on the Rights of Persons with Disabilities and also the Indian legislation, at which time I was closely associated with her, and I must say, my admiration for her and respect for her immense knowledge grew day by day during all those day long grueling meetings. For even as we from the disability sector passionately spelt out our vision and our wish list, there she was, so astutely and patiently spelling out to us the possibilities, the plausibilities, the rational and the irrational. When I approached her for this session on World Disability Day today, we had a little talk on the way things had come about the last few years, the pluses and the minuses, and it was my request that she underline the possibilities and the positive way forward, as I do believe that we should capitalize on what we have and act on it rather than sit back and rue what we do not have. And Amita Di, to my delight, agreed to do so. So here we are now with Amita Dhanda's presentation. Let's all watch and gain from it.
Hi, everyone. I'm kind of coming to talk with you today because I had this conversation with Jayshree a few days back where she was extremely upset about that even though it's almost 4 years since the legislation on the rights of people with disabilities was passed, so many people don't even know about the law. And she felt that this kind of ignorance was like unforgivable. As a law person, on the other hand, I felt that Jayshree was putting too much faith into the law. She was seeing it as too much of a panacea. And I told her as much. I said, no, it may be worth, because if it is not happening, it's because there are certain inadequacies in the legislation, and maybe we should talk about the barriers and all of this kind of thing. And her point was, no, this is unnecessarily complicating things, and what potential is there in the law, we are not even realizing that, and we are just nitpicking and trying to find out what is it that the law cannot do, or what are the inadequacies in the law. She felt that we really need to talk about the potential of the law. If we keep talking about the potential of the law, then possibly progressively we would in fact realize the potential. On the other hand, if we were to keep focusing on the inadequacies of the law, we would only keep enhancing the inadequacies. Keeping that, I felt that there's something like what Jayshree said was in some manner almost eye-opening for me. And I think guided by her belief and her commitment and her vision, I went back to look at the Act of 2016. So what I am presenting to you today, and that's how I've titled this presentation also, and I'm calling it Building Disability Inclusive Spaces with the Law, I'm wanting us to go and look at the Act of 2016, not for what it is not doing, but for what we can do with it. And keeping that in mind, I sort of like what I'm planning to do is I'm going to be looking at what all can we do, or what are the various kinds of things which can be done with the RPD Act of 2016. In trying to work out what can be done with the Act of 2016, I am going to look at four parts. I'm going to look at the relationship or the connection between the Act of 2016 and CRPD, and what are the possibilities of that relationship. The second point I'm trying to lay thrust upon is the comprehensiveness of the legislation. The third is where I want to focus on how can we realize these rights that are guaranteed by the statute with performance. And lastly is what the thematic of my presentation is, that how the statute provides us with an opportunity to claim all spaces as disability inclusive spaces. To begin with the first one, implementing the CRPD. Even if you, any one of you've seen the Act of 2016, then you would know that the preamble of the statute is in fact incorporating all the principles which were incorporated in the UN Convention on the Rights of Persons with Disabilities. So whether we speak in terms of non-discrimination or equality of opportunity or accessibility or equality between men and women, all of those principles have been incorporated in the preamble of the Act of 2016. Now, what is the significance of a preamble in a statute? What happens is, in terms of when you interpret a law or interpret a legislation, which is what the Act of 2016 is, if you find in any section or any provision, the law is not very clear. You can't really make out what has been given to you and what has not been given to you, or two kinds of meanings can come. One which we may be claiming as people with disabilities, the other which may come from administrators or other people who have been asked to do certain things, on whom duties have been laid by the law. In that situation, what lands up happening is, to whatever non-clarity is there, ambiguity is there, you look at the preamble and you're guided by the preamble. So that is the significance of the preamble, that the preamble is, like you could say, the umpire. That is, if there are two kinds of meanings possible, whichever meaning which is in alignment with the preamble, that is the meaning which will prevail. I mean, in terms of legal interpretation, that's very important for all of us to know. So in a way, you can say the preamble becomes the backup for every provision of the Act of 2016. And it provides an opportunity for us to complete that which any one of us believes is incomplete in the Act. And I think this particular connection that the statute makes with the CRPD and the preamble makes with the rest of the legislation is extremely important if we are to be looking at the statute in that positive manner, that it's going to in some way spearhead for us the rights of people with disabilities. The second thing that I want to stress upon is the comprehensiveness of the law. It's like every right mentioned in the CRPD finds mention in the Act of 2016. And it's not just social economic rights like the Disability Act of 1995, but also civil political rights, also cultural rights. You are, as such, there isn't, like you could say, all manner of schemes and programs under every right. So you could say the breadth of the statute is something which is an extremely important point that has to be understood, that it's not just about resources. It's not just about what kind of money should be given to people with disabilities or should be given to the disability sector. It is also about participation. It is about the fact of that, yes, you cannot really do anything in your political, economic, social policy without the participation of persons with disabilities. Because you are saying equality and non-discrimination is like the flag bearer of the entire statute, it is like it's been given, your whole equality and non-discrimination, you can say, has been given as much importance as providing of services. The comprehensiveness of the statute, that in one way or the other, anything at all which we believe we require to be getting as people with disabilities, you could find a hook in the statute where you could sort of make that connection and say the law also asks you to do it. And how we can be using that is something I will come in later in my presentation. But I do want to stress on that this is the second big thing, which is a very, very plus point for the statute, is its comprehensiveness. The third thing that I want to sort of stress upon is that, you don't really get rights by them being in books. If they are there on paper, it doesn't really matter, because that paper it has to become like a living document. It has to be something which in fact guides practice. And guiding of practice means that we don't, and that is the point which I think Jayshree was making, that we don't just know about the law, we actually study it because it impacts upon us as people with disability most of all. And because it impacts most of all, if we don't know it like the back of our hand, no one else is obliged to. No one else is really worried about it. So it becomes that rights become real when you act on them. So I'm talking about they can be rendered real with performance. And I'm talking in terms of what that performance can be. One kind of performance, and which we are much more used to, like doing, is to lobbying with, say, state and central governments that, all right, see, the statute provides for such and such entitlement. Like, say, in the context of the present pandemic, the whole issue of disaster management or prevention having to be disability inclusive has been expressly provided in the Act of 2016. And because it has been expressly provided in the Act of 2016, we can actually continually keep making mention of that provision to advocate with the state and central governments as to what they should be doing. So that's one kind of performance I'm speaking about. The other, again, which we are kind of quite used to, is the whole question of moving courts. To be saying that this has been provided by the statute, it has not been done by the government or other concerned authorities or employers or, the industry and other people on whom obligations have been placed, and consequently use the path of judicial review to make them real. This is the use of the courts is something we are all much more familiar with, because we all know that steel was poured into the Act of 1995 largely by the courts. The statute itself was just a feel-good legislation, but because every provision of that statute was continually activated, it became a more powerful, real enactment. And the third, which is an equally important thing, is that we, of course, we lobby with the government, we insist upon and use and move the courts, but the third is also with whatever resources we possess. We say that the rights which have been guaranteed by the statute, if the state will not do it, or if the courts will not do it, we will do it. And I specifically had the manner in which the relief and rehabilitation for people with disabilities was organized during the Chennai floods. It was largely done by DPOs. It was like using the entire social media and creating a kind of a vibrant network, and to say that no, the life of a person with disability is no less in value as anyone else. And if rescue will not come from the state, we'll organize that rescue, because that rescue must happen. It's our right. And if there is no other way in which it can be realized, we are going to go ahead and do it. So I definitely do think that rendering rights real with performance should also include this whole range of civil society initiatives. I am not in any which way saying that we should let the state off the hook. But what I am saying, and that's what my last slide is about, I am saying is that it's important. The reason why very often we need to take that law into our own hands or insist that everyone has to act according to the law is because in the imagination of most people, there is a certain way you look at people with disabilities. You look at them as vulnerable and deficient and helpless. I'm sorry, I mean, it's like we have really moved far ahead, but we can't really say that those images or those perspectives have gone away. So as a reason of that, it's important to constantly keep challenging the overarching. I don't see anything wrong with vulnerability. In fact, in a large part of my speaking and writing, I always say that if we want to be really talking in terms of interdependence and recognizing that vulnerability is a very integral part of human condition, then we need to be looking at disability rights. But on the other hand, I'm also sort of saying is that we can't continually keep presenting or talking about disability becomes interchangeable with helplessness and vulnerability. That is also not an acceptable thing. And the second thing is that if you sort of say, if they will not do it, we will do it. And if your presence is constantly felt, then what starts to happen is that you get into the psyche of people. It is like if a policy program is being made, people start to think, the non-disabled world starts to think, okay, but what is the disability perspective on it? Let us please try to find out, because otherwise these guys will agitate. They will come and protest. And that protesting, that agitating, that sort of saying that, yes, this is a claim that has been given to us and we are going to demand it without embarrassment or shame, is a very important part of making for disability inclusive spaces. The Act of 2016, as I have already mentioned to you, is a comprehensive legislation, and it sort of covers every part of life or every dimension of life. And if we insist that we claim those spaces, we are only acting in accordance with the law, but we are kind of making the non-disabled world cognizant of the presence of people with disabilities, of the presence of disability. And I think that's an extremely important step that has to be made, or that's an extremely important strategy that needs to be sort of executed on all the time basis. So in conclusion, I would say that the biggest opportunity we have today is that we have a disability friendly law. And I am saying that we can use that law, our familiarity with that law can be used to claim and obtain that which is ours. So we should not look at the law as only the implementation of the law as only an obligation of the state or of the government and of the courts. We should as much take the law into our own hands and insist on that what has been guaranteed to us in the book of the law has to be provided to us in the reality of our lives. Thank you so much.